our Digital Economy Hub. I'm Laura Johnston, Principal at William Buck Gold Coast. Today I'm joined remotely by my fellow colleague Eric, our other principal on the Gold Coast, who's unfortunately stuck in France. And today's topic probably hits a little bit close to home for him. He's stuck in France because he had to go home to deal with some estate planning matters. So he's going to use his background to shed a bit of a light on this for us and how that plays with the digital economy and what you need to look out for. So let's go, Eric.
Thanks, Laura. Thanks for this warm introduction. So estate planning is obviously something that is very relevant to me right now because it's something that I've been doing for the last month in relation to my own father. And while not a lawyer, I still see the importance of educating my clients about estate planning. That's a crucial part of my role as a business advisor and their personal advisor. It seems like many people devote more time to planning a holiday, choosing a house, or even selecting a spot to have dinner than they do to do estate planning. And while it's fun to think about all this stuff, at the end of the day, without estate planning, they can't really choose who gets everything that they've worked hard for all their lives. And most of the time is a bit of a miss. As you know, Laura, a good estate plan protects beneficiaries and young children. It can spare big tax bites, and if done properly, can also eliminate the likeliness of a family mess down the track. I'm sure we all have experienced a little bit of an inheritance disaster that have torn a few families. And for those who actually have started to plan, they may have thought about, their house, their old cars, their old pendulum clocks, or, any kinds of family heirlooms in addition to their properties, I must say. But not a lot of people think about their digital assets. And when you think about it, the digital life is really taking over right now. And it's something that we really need to all think about.
So, I was going to say, what is the more specific details people need to take into account with regard to their digital assets?
Well, as you know, Laura, digital assets, except for a few of them, like website domain names, they're not the same assets that form part of an estate. Sorry, these assets do not form part of personal property per se. So a court cannot order to be transferred during the passing, during, the execution of a will, like any other sort of physical property. And that is because there's actually no current law in Australia that governs them. So an attorney, for example, upon incapacity, or executors upon death, do not have an automatic authority to access the digital assets. And that's really why we need to think about it and how that's going to come about. The nominated person, may be the attorney, the executor, or someone else, not only needs to know about the detailed existence of a digital asset portfolio, but it also has to have the knowledge and ability to retrieve and control it. And on top of that, they also have the lawful right to deal with it.
Wow, that sounds pretty scary that there's no law that governs that at the moment. So, in your opinion, how would you deal with that uncertainty?
Well, it's prudent to plan what to do with your digital assets in the event of an incapacity or death. So you may minimize certain risks, like the prevention of required asset transfers to family members who may not have access or awareness of personal digital assets. You also need to identify theft after death, which may jeopardize digital assets or lead to loss for estate beneficiaries. There's actually been, from personal experience, people trying to impersonate my father after his death, sending emails around his emailing list, trying to get, monies for the funerals and things like that. So I can tell you, it is something that really happens. And if you do not protect yourself, it's not only about knowing your digital assets upon death, it's also about protecting them. But there's also issues with social media, including pages being defaced and awkward invitation to a deceased person because of a continuing online presence. And obviously you do not want that. People are grieving. It's the last thing that you want, receiving a friend's request on Facebook from someone that is deceased.
Wow, that would be pretty upsetting. I think I've seen on Facebook that they've got new protocols for that.
Yeah, and I'll talk about it later. But coming back to your original question, Laura, the first thing that people need to do is to create a digital inventory, or most of the time referred to as an e-register, of all their digital assets. That includes the username, the password, any secret questions, any two-step identification processes that are required to access all that digital sort of portfolio. When creating an e-register, the most appropriate thing to do, I think, to start with, is to list all the assets. And that list can include, all your movies, your ebooks, your music and other medias, as well as the services that obviously you go through to get them. There's also a good chance people have a large archive of digital photos somewhere, even if they're not sure where. They should not forget about, online accounts such as social media, like we talked about, online banking accounts, your cryptocurrencies portfolios, your PayPal, your online banking records, your online share trading records, loyalty, even incentive programs, it's like your flybys or your frequent flyer programs.
Wow, there's so much more to consider than I thought.
Yeah, and that's not the end of it. Another important one, Laura, is email accounts. They're really important because they may contain important information or attach files that the family could need in the future, or simply would allow you to regain access of all these things that we talked about before, by, forgetting the password or resetting anything.
Yeah.
Most of the time, your email account is the first thing that these providers use. So there's other things like your online storage and backup services. Your Google Drive, your OneDrive, your iCloud, your Dropbox, and I'm sure I'm forgetting a few. That is one thing, but that list can also include any physical sort of storage devices that you may have. Your computer, your iPhone, your iPad, any USB hard drives, etc., etc. So, and that list in itself is not exhaustive. There would be plenty more to add on to it. So it's really a good opportunity for people to actually sit down and look at it all and start listing them.
Wow, that would be a really long list for a lot of people.
Yeah. But on top of doing that, Laura, there's other things that these people can do. They can take the opportunity to, while making that list, to clean up and organize their digital folders. And why not, clean it? And maybe things in there that they do not want the heirs to see, or things in there that probably shouldn't be there, or doubled up that could be deleted to, clear out a bit of that digital clutter.
Yeah, that sounds really good. Clutter, digital clutter, that's a new one.
Yeah, and God knows we all have one. We all have some clutter.
So you said that there's no Australian law that binds this. Is there any other regulations that help plan this sort of digital estate planning?
Well, yes and no. I mean, there's no real regulations out there, and there's a lot of talks about getting some, but unfortunately, most of these talks and most of the laws would be state-based. So whether you're in Queensland, New South Wales, things will change. At this stage, there are some practical recommendations made, and I think New South Wales will probably be the first state to come up with procedures and a few other things that will give power to the courts, to the executor, to start doing all these sort of things. But at this stage, no, I can't really say that there is anything that governs it all. And that's probably why this conversation is really important to have during the living. It's easy to transfer property down the track. If you forget it in your will, there will be some law that will give rights, whether under family law, whether under, but when it comes to digital assets, if it's not that will during the living or explicitly in the will, then there's really nothing that people can do. And there could be a lot of loss along the way.
Yeah, wow, it's
Yeah.
certainly an issue to consider going forward, especially in this digital generation. Clients have their list. What to do with the list now?
Well, they need to decide how to keep that list. And when I say how to keep that list, it's not only where to have it, where to record it, but it's also how to maintain it down the track. That list, as you know, your password change, your username keep on changing. If you've got two-step identification, that also needs to be updated. So that's really not something that you live in a box somewhere and you don't go back to. It's really something that you need to continuously look at and update, because you don't know when that day is going to come, unfortunately. So, there's numerous internet sites already offering online inventories or registers, but it could be as simple as creating a digital document in Word that you store on a USB in a hard drive, or as a hard copy in your drawer, or in your lawyer's safe box. I don't know. But the important thing is that this list should list all the digital assets with their respective access details, and on top of being stored in a secure place, like as I said, your bank deposit box, your lawyer's custody room. It also needs to store the data and allow access to those nominated persons. So that's really important that you also now start thinking about who those persons will be. And of course, make sure that it's sealed with a password, in a sealed envelope or something like that.
Yeah, I was going to say that's a really important document that you wouldn't want getting into the wrong hands.
Absolutely. But going back to what you were saying before, Laura, about the lack of regulations or laws that sort of governs digital asset planning, there's still some things that you can do to make sure that e-register is dealt with and properly within your overall estate plan. And for that, like any estate planning considerations, you need to leave explicit instructions as to how you want your digital assets to be dealt with. And this may involve considerations like whether and how the attorney or the executor is to access and manage digital assets. So that we said that. It could be whether the digital asset is to be gifted or disposed upon incapacity or death, whatever that is, bearing in mind that some assets are owned, while others only grant contractual rights or access of use. So that again puts a little bit of a layer of complexity into it all, and why another important sort of consideration to have and to talk to experts right now to see there's things that you can do right now to go around this and to facilitate that transition down the track. You need to consider who can access and deal with a deceased person or incapacitated person digital assets. Again, you may want to have some people having access to a bunch of digital assets, while others would get access to another part of your digital portfolio. Again, we talked about the laws and regulations evolving around that. That's also another consideration that will need to be reviewed, because what I am saying now is probably not going to be relevant in 6 months' time, a year time, or things may have significantly changed, as I was mentioning before. And if the person is not the executor, that person that you've nominated to deal with your digital portfolio, there could be any requirements for that authorized third party to report back to the executor in the context of the overall estate plan. So that's also a very important consideration. Those people may be different, but they're going to have to work together.
Yeah, I was going to ask you that. In your experience, have you seen any issues in terms of gaining access to those digital assets, even when you are the nominated person?
Yeah. Well, I guess I am not a lawyer here, so the first thing, I guess, when you're planning for that is to go and get proper advice from a lawyer, and this is what I probably work with my clients and their legal advisor to make sure that everything is in place, all legal instruments are in place to make sure that that's happening. For example, when you're planning for incapacity, that's really important to have an enduring power of attorney, allowing anyone to appoint someone that they trust and who is a minimum tech savvy, I would say, to deal with those digital assets. But when it comes to planning for death, the will should include a clause that will give power to an executor to handle and manage the digital assets in accordance with the terms of the will.
Yeah. So we loosely touched on before. Have you seen any providers dealing with the afterlife allowances and how people can take control of those digital assets or profiles, things like that?
Yeah. So that's also a very complex point, and again, why we need to surround ourselves with experts in the area and start thinking about it now rather than later. It's important to keep in mind that despite having appropriate will powers, executors may also be limited to what they can do with those digital assets. So, for example, providers of online accounts require users to accept the terms of use agreements that obviously then determine the ownership and authority in relation to their accounts. So in most cases, users do not own the uploaded information or any associated rights to that information. So the providers may actually refuse access to the executor or next of kin. So as you said, some providers offer afterlife options, and you mentioned that before. Facebook is a good example. It's got what we call now a memorial feature, allowing friends and families to request that a deceased account become effectively frozen. Google has launched something similar. It's called an inactive account manager, allowing users to provide Google with specific instructions as to what to do after they pass. Twitter works with the person authorized to deal with your estate. So after a request is made, the authorized person needs to provide a copy of the death certificate and their identification. So these obviously have an afterlife option, as you mentioned, but there's a majority of social media and financial providers that do not offer afterlife options with their online accounts. And Apple is one of them, for example. And looking at the terms and conditions, let me read an extract to you. Any rights to your Apple ID or content with your account terminate upon your death. Upon receipt of a copy of the death certificate, your account may be terminated and all content within your account deleted. I do not like that term, may be terminated, but I think it means what it means. And that's probably why you may want to, shift from one provider to another during your living, if that's something that you want, or just move some of your digital assets that you do not want to pass on after your death. So all of this, again, it's really important for us to start thinking of this before it's too late. But not only to start thinking about it, but to plan for it, and obviously to make sure that you surround yourself with the proper experts and continuously review that plan. And that's what William Buck advisors can do for you. Obviously, they cannot advise on any legal terms around this area, but they can certainly hold your hand and use their network to basically have you surrounded with a proper team of advisors that will obviously work on your estate plan, including a digital plan component, and really help you project manage it all and make sure that that's easy for you, your executor, and your beneficiaries.
Wow, you've given me a lot to think about. I can think I've got nearly all of the accounts you mentioned and do not have a plan for my digital assets. So that's something to work on the weekend. I think you're really right that while we cannot help with the legal framework around it, we're probably best placed to help our clients as their trusted advisors. We know their business. We have, experience seeing, like you touched on, I think every accountant I know has seen a bad estate matter go
Yeah.
go through. So it's really important to have that dealt with. So thanks very much, Eric, for joining us from France in the middle of the night.
Thank you.
To share your
It's my
experience.
pleasure, Laura.
We look forward to talking to you again soon in person.
Thank you very much. See you soon. Bye.